Negligent misstatement. This is what's really important for you guys, because this is talking about advice that is negligent. Now, throughout your career, you will provide advice that has significant implications to your client, whether you're an in-house accountant or a private practice, that could result in someone losing a substantial amount of money. Now, there is ways of protecting yourself. I'd always have insurance. Insurance. But make sure you read the policy, because there's big print insurance, and they give with the big, take with the small, if you know what I mean. You read that fine print, you'll find out that you're not covered for a bunch of stuff, which could be negligence. Make sure your insurance coverage is right for you. In any case, negligent misstatement is very similar to negligence for injury. We follow a similar process, but we're talking about someone giving someone advice. Now, the only difference between negligent misstatement and negligence pure is the duty of care element. The rest of it's the same. But whether someone owes a duty of care for negligent misstatement depends on the existence of a special relationship. And we use a 3-step test to determine whether something is of a special relationship. The first one is, was the advice of a business or serious nature? Very easy to determine. If it's about purchasing a property, purchasing an investment, it's automatically about business. If it's about who's going to win the football, unless you know the individual's in the business of gambling or something like that, it can be a business. Tax guys come after gamblers sometimes because it's an income. But this is usually easy to satisfy. Secondly, did the person know or ought to have known that the person was going to rely on their advice? So by giving the advice, did you go, well, yeah, you can buy that house. And you know by saying you can buy that house because it's a good deal, that they're going to say, Nick said it was a good deal, I'm going to buy it. However, the third one is a bit harder. Is it reasonable in the circumstances for the person to rely on the advice? It gives us an exit in circumstances where you're giving advice in a social setting. So, someone bumps into you in the supermarket. They're a long-time friend, they know you're an accountant. You're in your dressing gown, I don't know why, it's 9 p.m, you're going home, and they ask you for advice about an investment. Now, I'm always going to say as a lawyer, don't give anyone advice anyway, just say sorry. But if you were to give them advice in those circumstances, it's probably not going to be reasonable that they rely on it because of the social setting. Similarly, if you're giving advice at a barbecue, I'm not going to call it advice, you're just having a conversation. Probably not reasonable in the circumstances. However, if a client is coming to your place of practice, it's 100% reasonable in those circumstances that they would rely on the advice. This one's a little bit grey. And it's where we have a lot of our arguments. Let's say, for example, Scott Pape. Now, he hasn't had any cases, but he is a financial investment expert who gives advice on the radio. Someone who calls up might say, hey, Scott, what's a good way of investing my money? Or similarly, he might provide some ad hoc advice on the radio. Should he be liable for that advice if something goes wrong? Probably not. It's probably not reasonable in the circumstances. Can you imagine the outcome if he was? We would not share information. I wouldn't even be able to lecture. Because technically, am I giving you legal advice? I'm not, but... So the person giving advice may owe a duty of care in those circumstances, and it doesn't necessarily have to be in a professional advisory setting, and I'll explain what that means. So we have a case of Hedley Byrne and Heller, where we've got a bank who provided advice. So Hedley Byrne is an advertising agency, and they advertise on behalf of a client called Easy Power. Now, Hedley Byrne doesn't want to get burnt. So what they do is they go to Easy Power's bank to ask whether they've got a good financial standing. Because before they do the advertising work, they want to know that they're going to get paid. and this company's going to go under. The bank wrote a note saying yes, they're in good financial standing. Turns out Easy Power weren't, and they went into liquidation shortly after, and Hedley Byrne lost a lot of money. Now, Hedley Byrne argued that they entered into that transaction based on the bank's advice. And they did. They relied on that advice. Could Hedley Byrne claim from the bank in these circumstances? Let's see if they've got a duty of care. It's of a business or serious nature. You can probably expect that the person they were giving this information intended to rely on it. Probably. And in the circumstances, it's probably reasonable. You're a bank. You've got intimate knowledge of Easy Power's financial standing. That person is going to think, well, the bank knows more about this financial standing than anyone else. I'm going to rely on what they say to me as being true. Duty of care is owed in that circumstance. Now, note though, this bank had a disclaimer in their advice that said, we're not liable for any advice. That disclaimer was effective, and we'll talk about disclaimers in contract law, because what they do is they're a way or a mechanism of limiting or reducing your liability. So by disclaiming and saying you cannot rely on this advice, although they were negligent in a way, all their compensation was taken away with this disclaimer. Having a good disclaimer is useful. We'll talk about that in contract law and how that applies, because sometimes disclaimers can be read down and against you. But in summary, the difference between negligent misstatement and general negligence is that assessment of a duty of care. You don't need to go through Donoghue and Stevenson. You need to go through Hedley Byrne's three-step test. Business nature, intended to rely, reasonable in the circumstances. You're not talking about Donoghue and Stevenson, you're replacing it with Hedley and Byrne. So, make sense? Yeah. Sorry, mate? Yes, absolutely. So all three have to be satisfied. All elements of that duty of care need to be satisfied. Now, once you prove a duty of care, though, you then go through standard of care, harm, remoteness. And they're the same as general negligence. So what's the probability? What's the likelihood of the harm? What's the reasonable to taking precaution? In those examples, it's things like taking time to give advice, doing some research. Let's think about how much money the person could lose. In those circumstances, the consultant's going to be required to hold a higher standard of care. Now, you don't necessarily have to be in the business of giving advice. It's irrelevant. But you do need to satisfy those three elements: business, intended to rely, and reasonable in the circumstances. One council got in trouble for giving advice over the phone to a property purchaser. So Shattuck wanted to purchase this property. They called up the council, or their solicitor called up the council to see whether there was any planned road works in that area or planned expansions of the road in the area. And the person on the phone said no, there was no planned works there. This was in fact untrue, and the council wanted to expand or make the road wider, and they did. And as part of doing this, it meant that the property value was diminished quite significantly, and in fact it encroached on the property itself. So Shattuck's bought this property based on advice that there's no planned road extension, and then they've bought it, and in fact then the road gets expanded. They've then sued the council based on negligent misstatement, because the council of all should know whether there's a planned road expansion. Anyway, the duty of care was satisfied because buying a house or property is business in nature or serious in nature. That was something that the council should have known or ought to have known, that by saying that there was no road planning, that person would rely on that advice. They called them up specifically for that advice. And it's reasonable in the circumstances because the council should know, and they're acting in their capacity as a counsel by responding to the question. For us, we'll probably just see examples of professionals acting in their profession, but just know that if you're working as something else, you can also be caught. Excellent. So back to Bruce and Sally. We know Bruce has been injured, but what about the money he invested and lost? So remember Sally told him, imagine if you put all your money, all your life savings in these 4 banks. You could retire tomorrow. Now, we don't know whether Sally's RG146, but let's put the regs aside. Whilst in the waiting room, he's hit his head and he decides to invest all of his money in which bank? Does anyone know which bank is which bank? Commonwealth, the yellow bank. He's put all his money there, and then financial inquiry, probably what we expected the Royal Commission to do but didn't do. Actually, I think the banks got out pretty good in comparison to the mortgage brokers. Looks like a bit of a, let's put the blame onto someone else, and let's clear out the market for the banks. Anyway, I digress. So after the financial inquiry, the bank shares have plummeted. Bruce loses all of his savings. How do we approach this? What's the first thing we look at? Legal issues. Excellent. And what's the legal issue? Excellent. So does Sally owe a duty of care? And has she committed what we call negligent misstatement by giving this advice to Bruce? So there's our steps. Duty of care. So this one steps out the rule. A person is liable for negligent misstatement if the advice relates to business matters, the advisor should have known that the other person intended to rely on that advice, and it is reasonable to assume that the receiver relied on that advice. Yeah?
Was that advice given before or after
That is a good question because it does make a huge difference. It was before, and then he's hit his head, and then he's invested. You reckon she's not liable?
Well, she shouldn't take his money because he hit his head.
That's true.
So she's got responsibility.
What's interesting is he just made the transaction himself. Now, I'm not sure whether in reality that is how it would work.
You can't sort it.
So we go through the steps. I like your thinking, though. We can see that there's a special relationship. Now, I've got a little bit of a sentence in there about giving financial advice. She's an accountant. Now, just because you're an accountant doesn't mean you can just give financial advice. You might know things about finance. Maybe. You might go into roles as a CFO. But technically, you can't give financial services advice. But putting all that regulatory stuff aside, we know from Shaddock and Parramatta Council, you gave the advice, it doesn't matter that it was part of your profession or not. You held out that you had that expertise. Someone stuck? Hey. That's all right. So Sally might argue that Bruce should have known that he can't get stockbroking advice from her. He's a tax advisor. You came here for tax advice, not investment. So that might be an argument for you. But, as I always do, it's very difficult in practice when you've got professional expertise. Your friends will ask you for advice all the time. They might already be starting to ask you for advice. I know for me, in a lot of social situations, the first, they have a traffic ticket, they come to me straight away. They want to sign an NDA for a book company, they come to me. It is incredibly difficult, though, and you have to be incredibly careful. I cannot give legal advice to them. And even though they're my friends, I have to say, I'm not touching it. I'm sorry, because you don't want to be liable for something in the end. The other thing is, because of your expertise, they'll believe that it's more true, going to that fact of reasonable reliance and things like that. And if something goes wrong, they'll say, well, you told me that was what to do. I'm going to come after you now. So be incredibly careful with that. It can be very difficult. Anyway, has Sally breached that duty? Well, someone in her position probably knew that the banks were going to be in a financial inquiry, maybe. So probably not something that was reasonably prudent to say go and invest in a bank, unless they were bottoming out and you've got some space up there, I guess. But probably say that that's gone beyond what she should be commenting about, and she's probably breached her standard of care there. Has that comment caused the harm, though? She's recommended that he invest, but the actual harm was caused by the Royal Commission findings, technically. So you might argue that her comment on what to purchase in terms of investments was not actually directly related to the harm. The stock itself was the harm. Perhaps. You could argue that either way, and lawyers would. Was the damage too remote? You could probably argue that it's reasonably foreseeable that someone giving financial advice could cause harm if it's wrong. But again, shares can be volatile. Is it reasonably foreseeable that harm would happen? So you may not satisfy all the elements of negligent misstatement. You may, though, as well. See how open it is to argue based on how we apply it? I would only talk about social utility if it's something that's an emergency or children or someone that's vulnerable. Generally speaking, social utility of an investment, it's probably not even there. So you wouldn't need to discuss it unless it's something that you would use in your argument to suggest that the standard of care would be changed. So generally not. It's kind of a rare one. You'd probably say the social utility, though, if you had to, and this is quite low. Investment of money is not really something that the society, from a public policy perspective, really cares about, which means that the standard of care would be brought down. But, brought up. But I'd just avoid it unless it's an emergency. So you could argue either way. And then you come to defences. And this is probably where you've probably got the most meat, because investing in something, you might say he contributed to his own loss. But you might also say that he didn't know what he was doing because he had a concussion, which was caused by Sally's wobbly chair. Maybe. Alternatively, has he voluntarily assumed the risk? Buying shares is volatile. What would your conclusions be? Do you think Sally is responsible? Hands up. Think she's got a problem? Do you think she'd be 100% liable or partially liable? Partially liable? And who thinks Sally wouldn't be negligent? Few. You could seriously argue this so many ways. Yep, absolutely. If she disclaimed at the start that this advice is not legal advice and shall not be, sorry, I used my own thing. This advice is not stockbroking advice. You should get your own. We always say, get your own independent advice. If you're not qualified to say something, always, even if you look like a fool, because it can, you're just having a social conversation on email and you say, this is not legal advice and not should be relied on as such, go get your own legal advice. It can always look a bit funny, but you have to do it. Have to do it. Yeah. And it's in the contract that you... Absolutely, and it says you've had the opportunity to, or you have engaged independent legal advice. So then the mortgage broker is not responsible for making you sign something under duress or under advice that's a little bit pushy? Absolutely.
And as asset finance and shares and that, as long as you use the correct proposal guide and product disclosure,
That's it. So having a good contractual document to get you started. Sometimes the law will dictate what you have to have in it. Unfair terms are a big thing with banks. Unconscionability is a big thing with banks. But always try and limit your liability where you can. And we talk about contracts over the next few weeks, because what really contracts are is risk allocation. Indemnities, insurances, and ensuring that your liability is limited to the most effective way possible. And one of those ways is to get the other person to get legal advice. That's also something to think about if you're entering into a business partnership with someone who doesn't have the same expertise as you. Because it can look like you've got an unfair advantage. If I was to enter into a business partnership with some of my friends that didn't have legal experience and I drafted the contract, how does that look from the outside? They don't know anything about the law, and I've drafted a contract and said, sign this. I could have put anything in there, and chances are I probably had all indemnities in my favour and all these different payments and liquidated damages, and if the partnership broke up, I owned all the IP or something. You have to make sure that they get their own legal advice if you've got an upper hand in terms of knowledge. Cool. Just don't do business with friends. I think that's the easiest way. Any questions about negligence? Yeah. Consequential loss is incredibly hard to calculate. Let's think of, and we talk about this in contract law, direct losses versus indirect losses. So you can see a direct loss as something that's come straight from the harm. So you've broken your leg. A direct loss would be the medical expenses and the costs associated with you not being able to work and the rehabilitation, things like that. An indirect loss, though, let's say that you were an up-and-coming football player. You haven't quite got there yet, but there's a possibility that you'll be a star one day. The indirect loss might be something that says, well, loss of reputation. Because you broke your leg, you're no longer going to have the same goodwill moving forward. Because you broke your leg, you're no longer going to have the same earning capacity. Now, that might be a direct loss, but what isn't a direct loss is savings, anticipated savings, for example. I would have made $1 million next year, which would have resulted in more savings in my bank account, which would have resulted in 3.5% more interest. Can you see how that's quite indirect? Generally speaking, in our contracts, we will say that neither party is liable for inconsequential losses, because you will argue for days what is an indirect loss. That can be quite a huge thing. But we'll talk about that in contract law. Yep. Yeah. So we probably try and deal with what we can see. And usually both parties will agree to limit indirect losses as a liability cap. You can go on in days. Loss of goodwill, loss of anticipated savings, loss of profits, loss of reputation can be a big one. Say you're in a band and you don't show up, your direct damage would be the loss of ticket sales, but have you damaged the reputation of that promoter? So they might be able to sue unless you've got a limitation of liability. So if you're in control of your contract, always have limitation of liability that says you're not responsible for inconsequential or indirect losses. And then have a liability cap that says, if anything does go wrong, I'm only going to be liable for $100. You can try. Might not be effective, but you see it a lot in American software. Anyone sign up to SaaS products like Spotify? if you read through the terms, you're probably only, let's say they cause you damage somehow, that you've breached intellectual property or something like that. Their cap probably is $100 US. And we see it a lot in IT in terms of data protection. Let's say the new European GDPR rules could result in a $20 million fine. Google just recently got a $50 million fine for breaches of privacy legislation around transparency. Let's say your SaaS partner breaches it and it causes you to suffer the regulatory fine of 20 million euro. But that SaaS product gives you a liability cap of $100. Can you see how much exposure you have there from that liability cap? It's huge. Anyway, let's do some Kahoot. What we'll get in a minute. Firstly, has anyone played on this before? Alrighty, so I'll just put a website up for us in a second. But if you grab your phone and go to a website called kahoot.it, and I'll put that up. So what will happen? You go to that website there, and it's got terrible music, I'm sorry. Kahoot.it, and it will give you a little pin to put in. 969651. And once you put that pin in, you can then put a name. Now you don't have to put your own name, it can be anonymous or whatever you like. Donald Trump's on there, all the way from the States. And what this is a bit of a quiz. So a question will go on the screen and you'll have 4 options. And those options will have a corresponding colour. And your job is to pick the colour that's correct in the quickest time. The people that selected in the quickest time get the highest score. And at the end we'll have 3 winners. And I have chocolate for the 3 winners. So there's some incentive to, one, hang around I guess, but also to have a go at the quiz. Is anyone not in that wants to be in? Struggling to get in? Ready to play? Yes, let's do it. First question. So this is from week 1, a bit of revision for us, introducing the law. The term common law refers to what? There's screens around the room too if you need them. Could be. Are you on your phone? No. You play? You know what? It's all good. It's all good. All of the above. Excellent. You got it right. So common law means a lot of different things. It means all of these things. So in terms of your multiple choice quiz, be careful because sometimes you'll get tricked like that. The first one looks right, bam, and I guess we've got time pressure. But it means the law that's made by judges. It's the legal system with which we're based on, and it's also a form of law that is separate from equity. Equity is a separate form of law. Cool. Lamia. Woo. Who's Lamia? You're winning. All right. Concurrent powers under the Australian Constitution are? Excellent. Concurrent powers means that both the state and the federal government can exercise or pass law there. Which one is exclusive powers? Which colour? Blue. Excellent. And which one's residual? Excellent. So they're the 3 powers that we have under the Constitution in terms of whether the state or the Commonwealth can pass those laws. Joe's out in front. So the ratio decidendi of the case of Dudley and Stephen is what? Who remembers what this case was about? Don't yell it out, but... Necessity is not a valid defense to murder. So even if you're starving, it's not a defense to commit the crime. Similarly to why a lot of people end up in Australia in the first place was they stole bread to survive. But here we are. Cool. Now that's a good example of a question you might get on the quiz. What is the ratio decidendi of a case? And then you're required to then look up that case and pick one out of the 5. Yeah. Someone's on a 3-answer streak. Cool. I actually don't remember that question. I don't know whether there's the right answer to this, actually. Sorry. I don't remember doing this. I think the lecturer has been playing with the quiz, but you know, if you do all the reading and you do the research assignment well and you do the feed forward, which helps with your marks, students really do good. So I've had some students going to the exam needing 2 marks. So if you front load your effort, make the exam really easy. I don't know about you guys, I hated exams. Like I preferred to have the time to write. Some people love exams. But take that as you will. The Australian legal system is not, I don't know what is it not, but which of the 4 is it not? It's not a democratic republic. Which country would we see automatically as a democratic republic? France, excellent. South Africa, Donald Trump. Not even the United States anymore, it's just Donald Trump. Trump Tower. So the Australian system is a constitutional monarchy. What does that mean? Run by the Queen. Excellent. But the Queen's not here. So who's the Queen's representative?
Governor General.
Excellent. The Governor General is the monarchy in Australia. Practically. Bam, bam, stamps the stamps. We're a liberal democracy because we vote for politicians to do stuff for us. And we're a federation because? Excellent. The states have come together as a federation. All right, Tommy up front. I think there's only one more question. The first rule of statutory interpretation that should be applied is... the literal rule. Every time you reach a question about statutory interpretation, we always go for the literal approach first. If the literal approach gives us something a bit silly or absurd, the courts have this golden rule to allow them to escape a literal interpretation. They've also got the purpose of approach, which is a bit broader. So sometimes a lot of confusion between the two. They're both an out, but the golden rule, think about it as more internal to the document, the context of the document itself. So reading it as a full. Whereas if you're looking at the purpose of approach, you're looking at all the context around it in terms of why was the legislation implemented in the first place, what was it trying to achieve, and to get to that aim, we'll look at things like the minister's reading speeches to get those ideas. Cool. Mo. Excellent. Millie. Is there a Millie? Millie and Tom. Awesome. I'll come back. I won't throw them because we just did a negligence lecture. Sorry, man. Awesome. So for some of us, it's probably the first time doing a Kahoot. Is that something that we like? You reckon do this a bit more? Yeah? Just the whole lecture of Kahoot? I think that'd be pretty cool. So we'll do them as a bit of a way of revising. I'll try and put them through the lectures in a little bit more detail. It is 9:15. We can... I know what you're going to say, so that's fine. We can end, or we can go over some problem questions from week 1 for 15 minutes, but totally up to you guys. The practice questions, sample solutions are published online, so you can give them a go and then submit them for feedback if you want. But otherwise, any questions about this week? No, have a good night. Until next one. Cheers. No worries, have a good night. Thanks, have a good night. See ya, have a good one.